Hello. In our series of the discussion about detection of crime, I want us to look at another important area in crime detection, prosecution, and within the broader field of criminal law. And this is about types and sources of evidence, especially those that are used in criminal law. Evidence is important in any criminal proceeding. Otherwise, without sufficient evidence, then criminals will walk out scot-free when presented in court. It is therefore the duty of the criminal investigator to ensure that they have sufficient and correct evidence to adduce in court in order for a successful conviction or a successful prosecution to be undertaken. So I want us to look at the types and sources of evidence in criminal law. Welcome. I wish first to observe that prosecution is generally designed to persuade and convince the judge or the adjudicator to find the suspect guilty of the crimes he or she is being alleged to have committed. And evidence in criminal cases is therefore any material information that can help or disprove a fact in any case that is presented in a court of law. Evidence therefore offers support to premises and conclusions that the investigator have laid against the suspect by elevating arguments beyond mere collection of personal opinions or prejudices. It is important to observe that if evidence do not point or cannot pin down a particular suspect of the crime, then it is possible for the suspect to allege bias and to see his or her prosecution as a personal vendetta against him rather than a criminal justice procedure that is meant to dispense justice to those whom the criminal has injured by committing crime. It is therefore important that evidence is presented thoroughly and in an adequate manner. Evidence is therefore one of the elements of proof. The second is reasoning. Indeed, as you present evidence in court, it should be followed out by well thought out reasoning. Because if reasoning does not accompany evidence, again, it can be quite difficult for the judge to make a ruling in favor of the prosecutor. It's therefore important that we look at this as a means of moving the audience towards the threshold that is necessary to grant adherence to the arguments. The audience here is the public, because every criminal case, there's a public interest into it. And therefore, we need to be moved to get persuaded and also to believe that the judgment that has been arrived at is one that is fair and one that is commensurate with the offense that the accused was presented before the court to answer. We want to look at the various types of evidence that at any one time investigators and prosecutors might be called upon to present in court in their effort to persuade the court to have the suspect convicted. But of course, even as we look at this, the other side of the same is that even defense lawyers, defense counsels, they also present their own evidence that is meant to exonerate or that is meant to weaken and to show the court that actually the accusations that are being leveled against a particular suspect are baseless. Now, Testimonial evidence is a type of evidence which is based on the opinions and actions of people who have knowledge of key facts that can be used to prove or negate a key element of the case. And the use of testimonials evidence may involve the use of quotes, opinions, or insights from experts or authorities in a particular field to support or negate a case. And testimonial evidence lends considerable credibility to a case as it demonstrates that knowledgeable professionals and authorities support their position on the case. Testimonial evidence is also used to strengthen a position by showing that what is being presented or argued is not just an opinion, but is also the opinion of someone that is recognized and respected in the subject under question. Therefore, testimonial evidence should be sound, rather should be sourced from reliable, respected, and reputable experts. When we talk of testimonies, we basically mean the opinions and the ideas that are being presented by witnesses. Testimonial might come from the victim of the crime, it might come from experts such as doctors, and it might come from even other sources. So any information that is obtained from witnesses and which the prosecutor seeks to rely on, or the defense counsel seeks to rely on, we call it testimonial evidence. And the people who will provide information that serves as testimonial evidence should ideally be people who have the knowledge and they also have facts as pertains to the issue in question. For the prosecutor, they will look for evidence that pins down the suspect to the crime that he or she is being alleged to have committed. But for the defense witness, the defense counsel, they may look for testimonials that seeks to exonerate the suspect and to show that actually the accusations that are being alleged against or heaped on the suspect are actually baseless and therefore should be dismissed. So testimonial is an important source of evidence. The other important source of evidence is called anecdotal evidence. And anecdotal evidence refers to personal stories or experiences that illustrate a particular point or support a claim. And this type of evidence can be effective in making an argument more relatable and engaging because it allows the court to see the issue through the lens of a real-life example. Anecdotal evidence is used to establish context, show relevance of the subject, or be a way to build an association or the link between or to link the suspect and crime. This type of evidence should be used, however, cautiously due to possible bias and may not sometimes represent the broader issue. It can involve a story about something that happened to an individual or an observation made about people, organizations, as well as institutions. When we talk of anecdotal evidence, in short, it simply means the prosecution trying to give the background, trying to give the storyline, trying to provide context under which the case is. And such context, if it is for the prosecution side, is meant to show that actually the suspect has a direct link to what has happened. For instance, a witness can come to court and give out the history of threats of the suspect, the kind of threats that he has given to the person that he eventually or she eventually hurt, and for which he is being brought to court to face justice. They can give the context, the story, the types, the number of abuse, and the types of abuses the person has leveled against the victim. And in that case, therefore, the design is to persuade the judge that what is happening is not just a one-off thing. The victim, rather the culprit, has a history of threats, and that the commission of the crime was merely the climax of that particular threat. So anecdotal evidence, it is meant to reinforce and provide context under which a particular case is being looked into. It is meant to provide the history, to provide the context, and to provide circumstances that, in the prosecution's belief, suggest that the person is actually linked to the crime that he or she is being prosecuted. Again, in the same vein, the defense counsel can also provide anecdotal evidence, perhaps to provide a history and a background that exists between the two, and to show that whatever that has happened is exceptional and therefore does not in any way show that or link the suspect to the crime that he or she is being accused of. The other type of evidence that might be provided in a criminal case is the one that we call statistical evidence. And statistical evidence involves presenting numbers as well as diagrammatical presentations, such as graphs and charts, to support the case. And this type of evidence is used to demonstrate the seriousness of the crime and the need for decisive action. For example, citing the number of people that die each year through road accidents might persuade the court that road safety is a serious matter that deserves attention. A case in point might be maybe a driver is being charged in court for causing accidents which has led to the death of several people, and therefore he or she is being judged to court for murder. And therefore, in terms of statistics, the prosecution might want to present the number of cases of road accidents in the country and studies that have shown that actually the cases are quite alarming, and therefore deterrent action on perpetrators of such road accidents is necessary if the problem is to be stopped or to be reduced drastically. And the use of statistics in a criminal case is also important in countering common misconceptions about certain issues. However, statistical evidence cannot be used to capture feelings, emotions, and other issues that cannot be subjected to parametric measures. For instance, it is easier to say that a family has lost 5 members in a road accident, but the actual feelings, the actual emotions, the actual social, psychological trauma that is associated with such losses might actually not be presented statistically. And therefore, perhaps other measures such as testimonials might be a more powerful tool that then can be used to persuade the judge that actually deaths arising from careless driving is going to cause untold suffering to the victims, and therefore serious measures in terms of deterrent punishment is necessary for individuals who flout traffic rules and who cause road accidents. The other type of evidence that can be presented in a court of law is what we call textual evidence. And textual evidence comes directly from a source document, such as a literary work or historical document, social media communications, letters, among others. Quoting statements from a text can be used to demonstrate their thought process, the thought processes of criminals and personality flaws, intentions, and background of the case at hand. Further, using the words of the suspect or witnesses that describe the character might lend support or exonerate the suspect through direct quotations or paraphrasing. Prosecutors and defense counsels often read or quote verses in holy books, statutes and constitutions, novels, reports, among others, to reinforce their position. Let me give a classic case. Say somebody threatened another person through a text message, WhatsApp message. and these threats were done and then sent to the person, and later on, out of that threat, the person got harmed or got hurt or even died. And therefore, there's a strong belief that the death is connected or associated with the threats that have been sent to him or her earlier. So in this case, therefore, the prosecution might want to look at those texts carefully and present them as evidence to show and suggest and to persuade the court that actually there is a need for the offender or the suspect to face justice because the texts that have been provided are indicators or are indicative of the issues that are before the court. So text messages, what we write, can actually be used as evidence in court, and such evidence sometimes might be stronger than other forms of evidence. So textual evidence is an important source of evidence or a type of evidence that can actually be presented in court and can be used to put the suspect to task and therefore link him or her to the offense that he or she is being accused of. The other type of evidence is called inculpatory evidence. And in criminal law, inculpatory evidence refers to evidence which is unfavorable to the accused in a criminal trial and which links him or her to the offense. In arguments, general arguments, or what we call creative and critical thinking, inculpatory evidence is one which is capable of rendering or unconvincing the argument of the opponent. This evidence can be in the form of previous criminal cases whose findings contradict or weaken the propositions being put forward by the defense counsel. Inculpatory evidence can also be in the form of previous stands taken by the opponent and which differ markedly with his or her current position or stand. In other words, what we mean here is that at all times, prosecution is expected, or criminal investigators are expected to provide strong evidence to suggest that the person who is being linked to the crime is actually the one that committed crime. This might even be past criminal record of the suspect. The criminal investigator can present past criminal record of the suspect, the history, and to show that actually this person has a history of committing crime, and it is therefore important for the court to bear that in mind while making a decision on whether or not to convict the person. So inculpatory evidence is one that is being used or being presented to suggest that by all indications, the suspect is actually the one that committed the crime. The opposite of inculpatory evidence is what we call exculpatory, and exculpatory evidence is now one that is offered by the defense counsel to show that the person that is being alleged to have committed crime actually has not committed the crime. Again, the defense counsel can also look at the history and bring out information or evidence that he or she believes has a higher degree of demonstrating that the accusation that the suspect has a very good record, and therefore the allegations that he committed crime are baseless. So while the prosecution side presents inculpatory evidence, the defense side will present the exculpatory evidence, and the aim is to show that the suspect has no link at all to the issues that he or she is being accused of. The other type of evidence is called corroborating evidence. And by corroborating evidence, we mean evidence which investigators use to strengthen or confirms already existing evidence, thereby supporting a proposition that's already supported by some initial evidence. And the primary function of corroborating evidence is the provision of direct evidence supporting the main conclusion. Its secondary function is to bolster or strengthen, which increases the probative value of some other piece of evidence in the case. And this type of evidence therefore used to confirm or authenticate other types of evidence that already are presented. And types of corroborated evidence might include medical records, court documents, signed affidavits, and even written statements sworn under oath. For example, if a person is being accused, say, of rape, and the witness has positively identified the rapist or the suspect as the one that raped her, right? Then with such testimony, it has to be supported by additional evidence. For example, the DNA tests that suggest that the person actually penetrated the woman. In that case, therefore, the additional evidence provides or strengthens already existing evidence. And in that case, therefore, the desire is to ensure that the person that is being accused by any standard has no chance of escaping justice. So when we talk of corroborative, we mean that piece of evidence that is meant to back up, to support, and to strengthen already existing evidence to ensure that the accused has no chance of escaping justice. I now want us to turn our attention to the various sources of evidence. One of the sources of evidence is called authority, and authority refers to a person, organization, or institution with expertise and specialized knowledge in a particular area gained from training, experience, and practice. Information generated from authority is considered as true and reliable since it was expressed by a respected person or institution. Legal authority is one of the sources of evidence, and legal authority emanates from laws, regulations, and governing systems. Then we have what we call traditional authority, which is rooted in long-standing customs, norms, and cultural practices. We have expert authority, which is derived from specialized knowledge, skills, or expertise in a particular field, such as doctors, criminal investigators, and the rest. Then we have moral authority, which is vested on the ethical principle, values, and a sense of justice systems that exist in society. Positional authority is authority that is vested on the individuals by virtue of the position they hold in a particular institution. For example, the Vice Chancellor has a positional authority to talk on certain issues about a university. Collective authority is authority that is a product of group consensus, the shared decision-making processes, agreements, general understanding on how we need to behave, on how we need to conduct ourselves under certain circumstances. So that becomes also important for us. Another important source of evidence is the empirical research. Empirical research is research that is based on observation and measurement of phenomena as directly experienced by the researcher. It involves the collection, organization, and analysis of evidence to increase understanding of a topic characterized by a particular attentiveness to controlling sources of bias as well as the error. This research type is founded on the view that direct observation of phenomena is a proper way to measure reality and generate truth about the world. And findings of empirical research is obtained through rigorous processes that ensure their validity and reliability, hence being considered as appropriate evidence. Therefore, empirical research as a source of evidence ensures that our arguments and presentations in a criminal proceeding are supported by facts and not mere assumptions. For example, assuming one intends to institute a criminal proceeding, say against industrial pollution, and that there's a belief that the industry emitted gases that are poisonous and that are injurious to society, and therefore there is need for such the owner of such industry and their management to take criminal responsibility. Then what would happen is that the prosecution might want to look at certain studies that have shown that the gas that is being emitted by that particular factory, causes certain elements that may have long-term or even fatal consequences on members of the society who happen to inhale such gases. So those studies, which if undertaken under strict scientific principles and guidance, can actually be presented in court to show that there is a need for deterrent measures to be taken against the industrialist who, out of neglect, ignorance, or sheer lack of a good heart for humanity, decided to pollute the environment, and that the consequences of such pollution are injurious to members of society, then the court can be persuaded, and based on such empirical evidence, can be guided by such, of course, alongside other sources of evidence, to find the industrialist culpable and therefore guilty of a criminal conduct. The other source of evidence, and which is the last in terms of this discussion, is what we call testimonial. A testimonial is evidence, is information provided by a person who witnessed something. And this form of evidence is mostly used in adjudication proceedings, where witnesses respond to questions posed to them during examination. When we present witnesses in court to show that, or to help us prove that the person being accused of committing crime actually committed crime, then that person becomes the source, and that source becomes what we call testimonial. An examination can be direct or cross-examination, where the former occurs when witnesses respond to questions from the attorney who presented them. Cross-examination occurs when witnesses respond to questions from the opposing legal team. So this is an important area, and most of the criminal cases, testimonial is one major and a critical component of the sources of evidence that are presented before courts of law. And judges have from time to time relied or have been persuaded by testimonials to render decisions against or for the accused. Thank you so much for your listening, and I want still urge you to take note of any information that you find require further explanation, so that we can create time and re-examine them. Thank you so much.